Judge Amy Coney Barrett laughs at Clint Eastwood in court, then discovers she is a legal genius. It was supposed to be an ordinary hearing. Judge Amy Coney Barrett, sharp as ever in her signature black robe, adjusted her reading glasses and looked down at the list of scheduled cases for the day. She had presided over dozens of high-stakes arguments and constitutional debates since joining the U.S. Supreme Court, but nothing prepared her for the moment that bailiff quietly leaned over and whispered, "Ma'am, the next case is Eastwood versus State of California." Her eyes widened slightly. Eastwood. The name rang a bell. She looked up, and then to the quiet gasp of everyone in the chamber, Clint Eastwood himself walked into the courtroom. Yes, the Clint Eastwood icon, actor, director, Hollywood legend. With his signature squint and slow, deliberate steps, he approached the podium, not as a defendant or a witness, but as a plaintiff representing himself. A murmur swept through the chamber. Amy couldn't help herself. She smiled, then chuckled. This has to be a publicity stunt, she thought. The bailiff called the case, and Eastwood cleared his throat. I stand before this court, he began, not as a man of film, but as a citizen whose constitutional rights have been quietly trampled. And just like that, the courtroom fell silent. Part 2, the claim. Clint Eastwood filed a case against the state of California, alleging that a newly passed law that restricted land use in certain mountainous areas had retroactively affected his private ranch in Carmel by the Sea. He claimed the law was unconstitutional, violating both the Takings Clause and due process under the 5th and 14th Amendments. To the amusement of some in the gallery, Eastwood had chosen to argue the case pro se without an attorney. He opened a worn leather binder, his voice calm, collected, and undeniably cinematic. "My ranch," he said, "has been in my family since I built it brick by brick in the 80s. I planted every tree, dug every well, raised horses, and raised children. The government now says I can't build a fence or maintain a road because it's a protected zone. That's not protection. That's theft with a signature." Judge Barrett watched him closely. She expected vague statements, emotional appeals, Hollywood drama. But then Clint Eastwood began quoting precise precedent. Nalin versus California Coastal Commission, 1987. The state required an easement across private property to obtain a building permit. The court ruled it an unconstitutional condition. Similar logic applies here. He went on in Lucas versus South Carolina Coastal Council. The court held that regulations that deprive all economically beneficial use of land are a taking requiring compensation. Amy leaned forward, her expression changing. This wasn't some celebrity stunt. This man knew the law. Part 3. A quiet rivalry awakens. Over the course of the next 3 days, the hearing unfolded like a legal thriller. Eastwood dismantled the state's environmental defense lawyers with precise language and clear reasoning. He spoke in metaphors, but they were grounded in logic. He cross-referenced federal and state statutes. He even corrected a state attorney's misquote of Penn Central versus New York City without notes. Barrett, initially amused, now sat quietly, almost in awe. During one recess, she confided in a fellow justice. "I think he's better prepared than most clerks who come before us. Possibly better than a few attorneys." The other justice raised an eyebrow. "Did you know he studied economics and political science before he ever became an actor?" "No," she said quietly. "But I'm beginning to believe he studied constitutional law, too." Part 4, the reveal. On the final day of the hearing, Eastwood introduced a single witness, an elderly woman named Linda Verson, a retired constitutional law professor from Stanford. She took the stand and said simply, "I taught him." Amy looked stunned. The woman smiled gently. "Yes, Clint was my student back in the early 2000s. He took a sabbatical from Hollywood. Quietly enrolled in my course under a different name, Charles W. Edgar. He sat in the back, asked tough questions, and turned in a final thesis on property rights and land use that could rival any Harvard graduate." Gasps filled the courtroom. Barrett's mouth parted slightly. Clint gave a small shrug. Just because a man doesn't flaunt his education doesn't mean he doesn't have one. Part 5, the verdict. After days of testimony, legal sparring, and an unexpected masterclass in constitutional interpretation, the Supreme Court deliberated, and the decision was unanimous. Clint Eastwood had won. Barrett read the decision herself. This court finds the retroactive application of California's environmental restriction to be unconstitutional under the Takings Clause. The plaintiff has successfully demonstrated not only a violation of rights, but the enduring power of the law when wielded by a citizen unafraid to challenge authority. She looked up at Clint. For a moment, she said nothing. Then she smiled, not in amusement, but in respect. "You've reminded this court," she said, "that genius doesn't always wear a robe." Clint nodded slightly, and justice doesn't always come with a law degree. Later that evening, long after the cameras had turned away and the reporters had filed their stories, Judge Amy Coney Barrett sat alone in her chambers. A soft rain tapped against the tall windows of the Supreme Court building, the marble pillars outside glowing faintly in the stormy light. She stared at her notes from the case, the arguments, the citations, the simple clarity with which Eastwood had framed his position. There was something humbling in the way he spoke. He hadn't leaned on academic jargon or philosophical abstractions. No, he had used the language of the Constitution the way it was meant to be used, plainly, powerfully, and personally. For a moment, she thought back to that first chuckle, the small laugh she allowed herself when she saw him walk in. It now felt like a bruise on her character. How often had she dismissed someone before they opened their mouth? How many arguments had she skimmed over because they came from people without pedigrees? She picked up her pen, wrote one sentence in her journal. "Today, I didn't just hear the law, I felt it." Part 8. A quiet legend walks away. Meanwhile, Clint Eastwood stood alone in front of the steps of the courthouse holding a small paper cup of coffee. The crowd had dispersed. The city lights flickered in the drizzle. Reporters had begged him for interviews. Universities had reached out asking him to guest lecture. Even the president had left a congratulatory message on his phone. But Clint, he didn't care for the noise. A young law student approached him nervously. "Mr. Eastwood, sir, I just wanted to say you changed the way I see everything. I thought I had to be rich or connected to change anything. But you just walked in and made it happen." Clint looked at the young man and gave the faintest of smiles. "Kid," he said, "I didn't walk in to change the world. I walked in to keep it from changing what's mine." He sipped his coffee. "But if that inspired you, well, maybe that's how the world changes anyway." And with that, he tipped his hat and walked into the misty night like one of his own characters. No applause, no curtain call, just the quiet dignity of a man who did what was right. Part 9. The Ripple Effect. Weeks passed, then months, but the Eastwood case, as it came to be known, didn't fade. In fact, it exploded into a national conversation about property rights, government overreach, and the power of the individual citizen. Legal forums began to offer special lectures titled "Learning from Eastwood: Common Sense in Constitutional Argument." A high school civics teacher in Ohio started assigning his students to watch the Supreme Court session, using Clint's speech as an example of rhetorical mastery and courage. More surprisingly, in a small town in rural Utah, a retired coal miner named Joe Reading read about the case and decided to take the EPA to court over a land restriction that had locked up his property for a decade. Inspired by Eastwood's style, Joe represented himself. He won, and that was just the beginning. People from all walks of life, farmers, small business owners, veterans, even first-generation immigrants, began taking a closer look at their rights and asking themselves the question, what would Clint have done? Part 10. A call from the bench. Back in Washington, Justice Barrett couldn't stop thinking about that case. It noted at her, not because she had ruled in Eastwood's favor, but because she almost hadn't listened. A few weeks later, she gathered her clerks in a closed meeting. They expected another legal discussion. Instead, she shared a moment of vulnerability. "We all studied at Harvard, Yale, Stanford," she said. "We've written papers. We've clerked for the finest judges, but don't you ever forget. None of that matters when the law is speaking from the heart of an ordinary American." Her clerk sat silently. She looked each one of them in the eye. "Next time a case comes in, I want you to read it like it's written by Eastwood. Strip away the grammar. Look past the format. Ask yourself, does this person have something to say that the Constitution should hear?" From that day forward, her chamber handled petitions differently, more humanly. Part 11. One last letter. Months later, Clint received a letter in the mail. It was from Judge Barrett. Inside was a short note written in neat cursive on official Supreme Court stationery. "Mr. Eastwood, thank you for reminding us that justice is not only something we interpret. Sometimes it's something we need to relearn. With respect, Amy Coney Barrett, he didn't frame it. He didn't show it to anyone. He folded it quietly and placed it in the back of that same leather binder he had brought to court. Then he walked out to the porch of his ranch, sat down in his old rocking chair, and watched the sunset roll over the hills. Epilogue: a man, a constitution, and a moment in history. There are people who make history through loud speeches, massive movements, or sweeping laws. But sometimes one man, one quiet voice in the right room can change the course of a nation. He didn't ride in on a horse. He didn't wear a suit. He didn't raise his voice, but he stood up. And because he did, a courtroom remembered what the Constitution was built for. Not for the elite, not for the powerful, but for the citizen. Just like Clint Eastwood, a year passed since the now legendary Eastwood versus California case. But its effect hadn't faded. In fact, it had only grown stronger. Law schools across the country began teaching a new unofficial term, the Eastwood Doctrine. At its core, it wasn't about property law or constitutional interpretation. It was about plain speech, citizen clarity, and the belief that the law should serve people, not intimidate them. One professor at Georgetown explained it like this: the Eastwood Doctrine reminds us that law must always be intelligible to the average citizen. It demands that we ask, would a rancher in Carmel understand this? If not, maybe we've lost the plot. In hearings across the country, you could now hear references like, Your Honor, in the spirit of Eastwood, let me speak plainly. Even federal judges began using the term in rulings, applying the Eastwood approach to property clarity or consistent with the constitutional reasoning modeled in Eastwood. Some laughed at it at first. Others called it populism dressed in legal robes, but no one could deny it was working, and the people loved it. Part 13. Barrett's Quiet Reform. Inside the Supreme Court, Judge Amy Coney Barrett had changed, too. Though quietly, she began advocating for what her clerks called the Accessibility Initiative. Her goal: make Supreme Court opinions clearer, shorter, and more understandable to non-lawyers. She even began adding plain English summaries to the end of her written opinions, a revolutionary act in the world of high legal discourse. Not all her colleagues agreed. Justice Mandel, a rigid constitutional originalist, scoffed. "We are not school teachers, Amy." But she replied calmly, "Maybe we should be at least some of the time." After all, she'd learned the hard way in that quiet courtroom that brilliance is meaningless if it can't be understood by the very people it governs. Part 14. Clint Eastwood, the reluctant speaker. Meanwhile, Clint Eastwood had no desire to write books or give TED Talks. But the world wouldn't leave him alone. He began receiving thousands of letters from ranchers, farmers, truck drivers, immigrants, even prison inmates. Some shared stories of injustice. Others just thanked him. One letter stood out. It was from a 17-year-old girl in Alabama who had watched the Eastwood hearing in her government class. She wrote, "I always thought the law was a thing for rich men in suits. But you stood up there with your quiet voice and proved it could belong to all of us. I want to go to law school now. I want to fight for people like my mom who never had a voice." Clint stared at that letter a long time. He sighed. The next week, he agreed to speak just once at a small town hall in Terry County. It wasn't televised. It wasn't live streamed, but the 100 people in the room never forgot it. He stood at the front, hat in hand, and simply said, "You don't need to raise your voice to be heard. You just need to speak from truth. And remember, the Constitution wasn't written in legalese. It was written so farmers could understand it. So don't ever think you don't belong in the fight for your rights." He paused. "And if you don't know the law, learn it. If you're afraid of the system, walk toward it, because that system is only as good as the people who demand it serve them." There was no applause, just the sound of people standing quietly out of deep respect. Part 15. A justice visits the ranch. 2 years after the case, a black SUV slowly made its way up a gravel road in Carmel, California. Amy Coney Barrett stepped out, dressed not in her judicial robe, but in jeans and a light jacket. She had sent no advance notice. She had simply written, "May I visit?" Clint welcomed her with a handshake and 2 cups of strong coffee. They sat on his porch in silence for a while, watching the horses graze. Finally, she spoke. "I wanted to thank you not just for what you did in court, but for how it changed me. I was trained to look at arguments, not people. But that day, I saw the person and it changed everything." Clint didn't respond right away. He just sipped his coffee and looked out over the fields. Then he said, "You listened. That's all I ever asked. Barrett smiled softly. You didn't just win a case, Clint. You reminded us what the law is supposed to be. He looked at her, and for the first time in years smiled fully. Well, he said, I reckon we both found justice. Just took a strange road to get there. Part 16, the final note. Years later, a small bronze plaque was installed in the Supreme Court building, not in the main chamber, but just outside the public viewing area. It read in honor of Clint Eastwood, citizen, plaintiff, patriot, for reminding us that justice belongs not to the robes, but to the people. No unveiling ceremony, no parade, just a quiet tribute, the way he would have wanted. 5 years after Clint Eastwood quietly walked out of the Supreme Court as a symbol of justice, his name still echoed in courtrooms, classrooms, and civic discussions across the country. But in a crumbling neighborhood in Detroit, 24-year-old Marissa Tate had never set foot in a courtroom. She worked 2 jobs, cashier by day, diner waitress by night. Her father had died from a factory accident when she was 13, and her mother had been fighting cancer for years. Life had been tough, but Marissa was tougher until the city decided to demolish the house her family had lived in for generations to make way for a revitalization project funded by a tech conglomerate and backed by the city council. No notice, no buyout, no mercy. They called it progress. She called it home. Part 18. A spark from the past. One night, sitting on the worn-out couch next to her mother, Marissa flipped through YouTube on their old smart TV. She wasn't looking for hope. She just needed background noise. But then a video popped up. Clint Eastwood destroys government lawyers in Supreme Court, full unedited case. She froze. The thumbnail showed a much older Eastwood standing alone in court. She clicked. 20 minutes later, she was sitting upright. By the end, her hands were trembling. This man just walked in. And won. Her mother, barely strong enough to sit up, whispered, maybe you should try. Try. Marissa laughed bitterly. I didn't finish college. I can't afford a lawyer. Her mom just looked at her. Neither could he. Part 19, the legacy lives. The next day, Marissa walked to the local legal aid office and requested a copy of her property rights under Michigan law. The receptionist handed her a basic packet and tried to dismiss her until Marissa looked her in the eye and said, I'm not here to lose. I'm here to speak. And I have a right to be heard. She started watching court videos at night, reading property case studies during lunch breaks. She learned what eminent domain meant. She discovered her house sat on protected historical ground. She even found an old city council document contradicting the demolition order. She filed the appeal herself. And when the court hearing came, she walked in alone. No lawyer, just a battered folder of notes and the fire of Eastwood in her voice. Part 20. Detroit versus Tate. The courtroom was smaller than the Supreme Court, but to Marissa it felt just as important. The city's attorneys wore tailored suits. They chuckled when she introduced herself as her own representative. But when she began to speak, that laughter stopped. She laid out her case clearly, calmly, relentlessly. She cited Clint Eastwood's case from 5 years earlier. She referenced Judge Barrett's Eastwood opinion. She quoted the Constitution. But most of all, she spoke as a citizen. My great-grandmother built that house with her hands. My father died working for this city, and I've paid my taxes since. I was 17. Now you want to bulldoze my history for a parking lot. Well, the law says no, and I'm here to make sure you remember that. The courtroom was silent. Part 21. A victory for the people. 2 weeks later, the ruling came in. The demolition order was overturned. The judge's written decision included this line. Miss Tate's defense stands as a modern embodiment of the Eastwood Doctrine. Clear citizen-led advocacy rooted in constitutional principle. Justice has been served not only by the law, but by the voice of the people. The ruling made national news. TV outlets ran segments titled, Detroit Girl Channel's Clint Eastwood Wins Against the System. Citizen Justice, How a Waitress Stopped a $1 Billion Project. Marissa was offered scholarships to study law. One university even renamed a Lou.